Thank you very much for attending, and hopefully we provide a little bit of information for you and a little bit of value around investors and how to evaluate intellectual property. It's a very hot topic these days, and there tends to be a little bit of confusion around what it is investors are actually looking for and what they're looking to evaluate and how to evaluate and when is the right time to evaluate the IP, because as we all probably are aware, it can get pretty expensive. And so you have to be conscientious about when to spend the money and when not to spend the money. So we're going to spend some time hopefully giving you some ideas to think about and ways to try to evaluate and make that decision on when it makes sense to engage with a firm like ourselves and kind of go through that process, and when it's worth the risk to maybe not do that. So a few considerations to kind of keep in mind. So we're going to go over just IP basics, and the reason that's important is because a lot of times people interchange the verbiage. So sometimes you'll be talking about a copyright and you really mean a trademark. Sometimes you're talking about a patent and you really mean a copyright or a trade secret. And so I think it's very important that we have the terminology and the nomenclature accurate, because if we don't, then it gets a little bit confusing on basically how to discuss those things, because each of them are their own bodies of law and they do make a difference and can have significant impacts. And if you think you need a copyright, you really need a patent, boy, that's a huge difference. So I'll go back. So that's on the IP basic side of it. Then there's kind of the risk reward about, what's the value add of having IP that's protectable and enforceable, and what's the risk around that as well. Then when you own IP, you got to also worry about infringement. So whether it's enforcing or avoiding infringement, how do you value the IP that you have? We'll talk about that a little bit. And then when you're dealing with acquisitions and due diligence that comes along with that, what are some things that you should be focused on when looking at those things? So we'll jump right in to the next slide, which is part of this IP basic. So on patents, patents are an invention. So, at a high level, and some of this might be a little bit redundant for some people on the call, but patents are an invention. Your invention is basically where, it's something that you can touch in many respects. Now, there are business methods, which are a little bit more intangible. A lot of software patents are around that side of it. But patents are inventions. There's something where you had an idea and you implemented that idea and you created something. And so when you have something that is somewhat tangible in nature, that's going to be your patent. Your next one is going to be trademarks. So your trademarks are basically going to be your brand. And so your brand, Coca-Cola, Nike, Pepsi, Microsoft, Google, right? That's your brand. So it doesn't have much to do necessarily with what your invention is or anything like that. It has to do with what your, at least in the US, the trademark laws do vary country to country, but in the US, it's about what is your brand that the consumer buys and sees, and what is the associated good or service with that brand. So in Coca-Cola's example, it's sodas, right? It's there's merchandise, of course, that they have, and then they get involved in things like sponsoring of events and different. They're in so many different areas at this stage, but at the core, they're a soda manufacturer, right? They're a bottling company. So Coca-Cola brand is linked to that. There's certainly rules around the level of famousness of a mark and things like that come into play, but generally speaking, it's the name associated with the good or service, and that's going to be your brand, your trademark. copyrights are going to be works of art. So artists create copyrights typically, and we all can be artists. Copyrights are typically thought of as a painting, a song, a movie, a book that's written, things like that. It can also apply to software in the US. You can get a copyright on software, on your code itself. Basically, the way it's written can be an artistic interpretation. So copyrights are those works of art. In M&A type scenarios or investor type scenarios, they don't come into play quite as often unless you're investing in media. NFTs are an interesting topic that non-fungible tokens that are coming up that, do have some copyright elements certainly associated with those. So it'll be interesting to see where that goes. But generally, copyrights are unless you're buying a media company, are not going to be a primary asset that you'd be looking into, but they are important to understand. And then, so, there's one that we miss up there, which is trade secrets, and trade secrets are definitely an important element. Trade secrets are secrets. It's kind of a silly definition of it, but that's really what they are. There's certainly an entire body of law about what is a trade secret and how do you keep it a trade secret and to make sure it stays and qualifies as a trade secret. But at the core, it's some sort of competitive advantage that gives you an edge over your competition. And if it is, then it's a trade secret. The problem with trade secrets is that if somebody reverse engineers them and does not get the information to those secrets through kind of an improper way, through maybe getting an employee that is under a confidentiality to disclose it or something like that, then it's not protectable in those scenarios. So one contrast is patents. So if I get a patent on something, I have a monopoly on it. It doesn't matter if somebody invents the same thing after I've already filed without knowing me or knowing anything about me. That doesn't matter. A patent gives you that ability. A trade secret, if you have a trade secret in your company, it can be very valuable. But if someone else figures it out, you can't stop that. It's no longer a secret. So those are discussions. We have those a lot, which is, do we want to keep it a trade secret or do we want to keep it a patent? And because with a patent, you also have to publicly disclose what you're doing. So that's part of the deal. You have to file with the USPTO or whichever jurisdiction in the world you're going to be filing, and it becomes public. It's public record. And once it publishes, it's out there. And so you can't pull it back at that point because it's already out there. So it can't be a trade secret anymore. So it becomes, especially if you're dealing with a lot of software companies, that becomes a big question mark that gets asked. So as we kind of laid the groundwork, and if you guys have more questions about differences between the different types of IP, we could certainly jump into that at a offline, or we may actually have another webinar where we just kind of focus in on that if that's of interest. But I wanted to really kind of hone in for what we're here for, which is, as an investor, what are you looking at from an IP perspective? So I think risk reward is probably a good way of just saying, that as an investor, you deal with risk reward in every decision that you make. So IP is no different. Having strong, valuable IP, it's got some great rewards. It helps block the competition. It gives you an avenue to be able to stop someone from competing against you. It helps to drive up the value of your portfolio, of your company. It justifies the price. So, there's some real value there. And I think over the last certainly 10 years or so, the value of IP, while it's probably always been there, has become more in the forefront. It kind of, gotten a lot more attention. Certainly the Apple-Samsung IP battle got a lot of attention. I think was Apple bought from Intel all the Qualcomm patents I think they had for $1 billion, or about 17,000 patents, right? So there's been a lot in the news over the last several years about the value of IP and about how it is. When it comes to, from an investor perspective, really what it does is it helps to kind of mitigate some of your risks. So, if you're investing in a startup, let's say, or a mid-size or a growing company, and they've got good, valuable IP, it can help mitigate your risk, because if that company fails in what it's doing, you could still have some assets still available that you could try to make your money back with. So it's not a complete flop potentially. So there are some value propositions there. If you invest in something that doesn't have any protectable IP and it doesn't work out, unless it has tangible assets such as cars or tables or physical objects that you can go and sell in the aftermarket or something like that, there may not be much left, right? So a lot of times, people think about making sure a company has IP because, you're investing, you're excited, you want it to grow. That's obviously why you're talking to this company, but there's some risk, diversification that can come with that as well. So that's something there as well. It's also important to remember you're investing in the invention, not the identity. So what do I mean by that? Well, your invention, the IP that you're investing in, maybe it may be used in the specific way that the current owners and founders are using it, but that IP may have other use cases for it. So what's an example of that? Well, a silly example might be, you might be investing in a computer chip manufacturer for computers, and you may also have a use case for those in other devices such as cameras or video game machines or things like that. So the only reason I bring this up, which is it may look very flashy or it may not look very flashy in terms of how the inventions and the IP is being portrayed. But remember, when you're investing in the IP, you're investing in the actual invention itself, not how it's being portrayed. And so you can use that in other avenues. You can use that in other ways. So that's an important thing to keep in mind. But again, if you don't have the protectable IP, it's not as versatile. So that's something to keep in mind. And then when we touch on licensing and diversification, those are other ways of kind of reducing some of your risk. So licensing, a lot of times people don't think of this, but you might have a very nice IP portfolio that you get when you invest in a company, when you acquire a company, and they may only be using it for their own product set. Well, if you've got a patent portfolio and there's some potential other use cases for it, you can help diversify that by looking into licensing. It doesn't mean you have to stop doing what you're doing, but it could be a way to, instead of trying to go and hit the competition over the head every time, which could also get expensive and sometimes works, sometimes doesn't work, you could look at embracing the licensing model where you try to get them to license from you. There's a whole industry of what we call patent trolls that are out there trying to do that. Same thing. They get a very bad name and reputation because they don't actually make any product. They just try to buy what they believe to be usable IP and then go after people that they believe are infringing and try to get a license deal. And that's basically their business model. So there's nothing illegal about it. It just gets frowned upon certainly by a lot of people, by a lot of the press. It just doesn't get a good reputation for what they do. One interesting twist to that, not to go off subject too much, but what a patent troll is, it's really a non-practicing entity. Universities are non-practicing entities. Research institutions are non-practicing entities. So sometimes we forget when we try to lump them together and say patent trolls are bad. By nature of what they're doing, they're owning IP that they do not make the product for, and they're trying to license it out. And that's exactly what all the universities in the country do. All the research facilities, for the most part, do. So you got to be a little careful when you kind of think about that side of it. And then the diversification is kind of touched back to what I was talking about on the invention side, which is, are there other use cases for the intellectual property? Typically on the trademark side, not a ton of different use cases, because you can't have different products in the same competing space under the same brand. So what I mean by that, which is the whole thing with trademarks is protecting the consumer, so that when they see Coca-Cola brand, they know they're getting a Coca-Cola. They're not accidentally getting a Pepsi, right? So, you know, part of it's about keeping the product intact, if you will, so that, you know, if it's a good product or a bad product, the consumer will know based upon the brand what type of quality they're going to be getting. So you can't really, you can license your trademark, there's no doubt about it, but you got to be careful. You can't have like 50 licenses of your trademark in the same space, and they're competing against each other. But in patents, you can. Patents, you can do that. So you could license your patent to 100 different companies that all compete against each other, and that's perfectly fine. So understanding the type of IP you have is important as well on that. There was a quick question about patent mining, I think. Let me pull that up. So he asked, what is patent mining? So if I understand what you know, I might need a little more context on what you mean when you ask that, but what I think you're talking about is where you have basically there's some companies and there's a lot of software written around this, which will try to basically comb through all of the issued patents and try to identify areas that that the markets are going in. And so they try to look and try to acquire and try to just kind of research and be ahead of the game on that side of it. So that might, I'm not sure if that's exactly what you're referring to, but that's certainly one form of kind of patent mining, where you're just kind of looking through the databases, trying to find particular types of patents that might not be being used, that you can then acquire or license, and then kind of build your product off of. But if I didn't answer your question, feel free to message me offline. We can talk more about it. So now that you have IP, or you're looking to invest in some IP, how do you avoid infringement? So this is something that certainly in the startup space and the early stage companies, I think gets missed a lot. And this is back to that balance of risk and reward, which is, you know, if you're investing $100,000 into a company, it doesn't make sense to spend $50,000 to see if you're infringing, if there's an infringement, right? So there's got to be a balance, right? Now, if you're spending $10 million, then spending 50 grand to make sure there's not an infringement makes a lot of sense. So you got to balance kind of how much due diligence you kind of do in this case. But when you're looking at how to avoid infringement, there's a couple things that I think are good kind of bits of information to make sure you're familiar with. So one is language, and under language we have claims sitting there. And the reason that's important is because a lot of times I hear, oh, well, this patent references my invention or my product or whatnot, therefore I might be infringing on it. That might be true, but it might not be true. And the reason is because in a patent, the only thing that's enforceable are the claims. The issued claims are what you can infringe upon. The rest of the specification, the rest of the information in the document, you can't really infringe upon. You can't get a patent on it because it's already been disclosed if it's in there. But when you look at what are you infringing upon, it would be the claims. So this comes up a lot in this, and particularly Amazon's a great example of this, where it's created this whole ecosystem of buying and selling product. And this is one thing that you got to be kind of careful of. You go and you buy a company or you invest in a company, if you're dealing with anything that's selling on Amazon, and you go, oh, look, they're selling, it's great, that's wonderful. And then you find out, oh, well, maybe a competitor has a patent. Uh-oh, right? Now, what do you do at that point? So the first thing you do is you look at the claims, you look at the language on the patent to see if their claims cover what your product is. That's what we do. And it's not as easy as it sounds, but that's where you would look first. And the reason is because a lot of times in the description of the patent, the specification, you will include a lot of additional things to give yourself wiggle room when you're trying to get the protection on the patent. And so looking at the claims is an important element, and really the only one that matters when it comes to, are you infringing? A search. So that's how you can do a fairly basic, relatively inexpensive patentability or patent search, just to try to get a decent understanding of, okay, are there things out there that I should be worried about? And there's different levels to this. There's kind of a basic search where you'll just kind of get somewhat the raw data back. And then there's kind of peeling the onion back a little bit and diving into what those search results are, and what's in those claims, and how does it compare to your product or your potential that you're investing in, your potential company or product that you're investing in. So the search can be a valuable tool. You also have to be careful. It can lead you down severe rabbit holes. And the other thing is in attorney world, in our world, we don't live in black and white. We live in the grays, and we live in percentages. So doing a search, a decent search or a good search, it will help to elevate the percentage of likelihood that you're not going to have a problem. But don't think it gets you to 100%. And I think that's important to understand. Sometimes people go, oh my God, I did a search, I can't believe it. How could this possibly come up, right? That sort of mindset. And you got to understand that there's, in the US alone, there's probably 6 or 7 million active patents right now. In the world, there's probably 30 or 40, maybe more, million patents that are active, enforceable kind of thing. So when you're searching in these databases, as you can imagine, there's just a ton out there. And so depending upon how you search, the keywords that are used, things like that, it's possible to miss some things. And so doing a due diligence search does make sense, but you also have to understand what you're getting, and make sure that you don't think you're getting a little bit more than what's actually coming through. The DOE, which is actually stands for Doctrine of Equivalence. The reason that's important is because that's like the one exception to the rule of if it doesn't infringe directly on the claims, but it's super close. I mean, it's one of those things where it's like, it's basically the same thing, but it doesn't read exactly on there. There's what's called a doctrine of equivalence, which can say that, well, it's basically the same thing. It doesn't read exactly on it, but it's basically the same thing. Therefore, it's still an infringement. As you can imagine, just from my stumbling over explaining it, it can be, it creates a lot of work for attorneys, and there's a lot of gray area with it. It's similar to in patent world, we deal with obviousness. In trademarks, we deal with called likelihood of confusion. In copyright, we deal with what's called fair use. So, there's these kind of sections of each of those types of law that are open for interpretation. And whenever that is, then it'll and it's not cut and dry, then it opens up the opportunity to make arguments around that. And it's both sides. So as the potential infringer, it opens up arguments, and as the IP holder or owner, it opens up arguments. So, but that's another important thing to think about, because sometimes sometimes people get a little bit kind of outsmart themselves, and they go, well, it's basically the exact same invention as the patent, but the teeniest of tweaks, but it's immaterial, and you think you can get around it. It may not be that's the case, and it requires a deeper analysis to make sure that you're there on that. So this is an important element of avoiding infringement for a couple of reasons. So, what you don't want to do is you don't want to be in a position where you invest in a company or you buy a company, and then after the fact you find out that there was, a patent you're directly infringing upon or something like that. So those are kind of the potential nightmare scenarios. And then you have to weigh the risks at that point of, one, is there a way to peel the deal back? Is that part of the docs that you guys signed? Is there a way to mitigate some of that risk in terms of, sharing an infringement risk or something like that? Or do you roll the dice and hope the patent holder that you found out after the fact or doesn't come after you? And that can definitely create some uncertainty because there's no requirement, particularly in patent world, where you have to, if you know about somebody that's infringing, you don't have to go after them right away. You can sit by and wait until they make some money and then go after them. Trademark law doesn't work quite that way. Trademark law is a little different. If you know someone's infringing on your brand, you have a duty under the law to go after them and enforce your brand. You can't sit by and wait for them to become a famous brand and then go, up, now we're going to go after you. But in patent law, you can. So that's another thing to think about. We have conversations a lot where a client will go, I'm not sure if they're going to even come after us. I don't really care. You might be right, but they might sell to someone who does want to come after you. And if that patent's still valid, they have the ability to do that. So you got to kind of make sure you're weighing those risks. And then kind of finally, I know we're coming up on our half hour. We could talk about this all day, but valuation methods. So I think that's an important thing to kind of think about, because certainly as startups or as early stage companies, if you're investing in those, how do you value this, right? It's a big question that comes up a lot. Here's 3 basic kind of methods that we can talk through just briefly. So obviously, if it's a pre-revenue company, income method isn't going to work very well because there's no cash flow. But that is one method that you can look at, especially if it's an established entity. How are they making money? Use that as a basis of valuing their IP. It makes it even easier if they're already licensing their IP, right? Those are easy ones. If they're not, then how are they making money? What value is the IP bringing to that? And so you can use kind of that income method. The market method is more speculative. So that's probably what would get used a little bit more in an early stage or a startup. And what can be the value of this, right? And how do you determine that? You kind of bring in some of the cost method a little bit to kind of do that, because you try to do the market method valuation by looking at somewhat similar-ish type companies and where their value has gone and what their kind of market penetration looks like, and how value the IP to them was, and how valuable their IP is. So that's another way of doing it. And then cost method is just simply comparing other types of IP. So if you have if you can find a cost basis for that. So if you can find someone that invented a chair and you're investing in someone that invented a chair and they sold their chair and their patent for their chair for $1 million, well, maybe you could, use that and say, okay, well, maybe that's a basis for starting the conversation about, okay, we'll start at $1 million and then negotiate from there or something like that. So there's not a perfect science by any means in this. And there's certainly accounting firms have their valuation methods and things like that. But the reality is, when it comes to IP, it's so dependent upon how you're going to use it and what you're going to do with it, that there's different ways of kind of monetizing it. So that comes into play as well. cost method is in fact the market method. So, and this might be a little outside of my realm as not being an accountant, Antoine, on this, but my understanding is that they're pretty, at least when it comes to the IP side of it, they're pretty closely related. But if you have a little bit to share on that, we certainly could talk about it. Thank you for bringing that up. Or you can go to the next page. So, this kind of all leads to, merger and acquisition. Merger and acquisition. So, now that you're in that, stage, whether you're buying or selling of your company, there's kind of three elements that I think you need to look for when it comes to due diligence. We've touched upon some of these already, but one thing that gets overlooked a lot is ownership. You go to invest in a company and you say, they say, we have this great IP, we've got patents filed, we've got some trademarks, so on and so forth. And then basically, you got to make sure that they own that IP. So I see things get missed a lot where the founder started creating the IP before the entity existed, keeps creating the IP, and never signed over an IP rights assignment to the company, right? So that can create some problems. That could create an issue down the line. God forbid, founder A gets hit by a bus. That IP that they've created might end up potentially in their own personal assets and not in the company's. And so that's what you want to certainly avoid. That's probably an extreme example. The more common example is you invest in a company, the founder and you don't get along, the founder then leaves, and then they try to compete against you directly by taking the IP they created. And then you go, wait a minute, I bought that. And then there's no actual assignment of ownership of that IP. And that's where a big time, where we see people get caught up a lot in that side of it. So some of these things are fairly simple to do that you need to integrate into your process. So when you're buying that IP, you want to make sure that you have proper ownership. That's very important. Freedom to operate, that comes into play. So we use that as a kind of a term of art, which is if you have a product you're taking to market and you want to make sure that you do this due diligence of, am I going to get slammed with a lawsuit? Am I going to get, in trouble? Am I going to, depending upon where I'm going to sell. So this is less about concerned about whether or not you can get a patent and more concerned about, is your product going to be infringed upon? I'm sorry, is going to be sued for infringement. And the freedom to operate becomes very specific because someone could have a patent in China, but not a patent in the UK, or someone could have a patent in the US, but not in Mexico, and so on and so forth. So depending upon where you plan to operate and distribute and sell, that would determine how to do the freedom to operate search and how to do that due diligence. So that's a bit involved, the freedom to operate, particularly if you choose multiple countries, because ultimately what we're having to do is you're paying generally a law firm to do this, to go through, do a detailed search in each country, look for active patents or about to issue patents, compare it to your product, and then give you an opinion letter on here's who you could be sued by, here's who you could not be sued by. So, it does take a bit of work, but depending upon the investment you're putting into it, it can make a lot of sense, but you just have to kind of weigh it against that. And then protection liability. So, we talked about a little bit earlier about what happens after the fact. You buy a company or you invest in it, and then you find out that there's a patent out there or two or three that you're infringing upon. What happens there? So, you want to make sure you have some protection and liability, within your agreements when you're making these investments and when you're purchasing companies, purchasing the rights to any sort of IP, things like that. Because if it turns out that you're investing in primarily an IP portfolio And that IP portfolio gets undercut because there's prior art that it gets challenged, and there's prior art that eliminates a patent or several patents. Well, you just paid a bunch of money for and paid a bunch of money to fight for it, and now you have nothing there. So it's important to have some protections and liabilities in place with whoever you're purchasing these from and investing in. I think that's something that sometimes it doesn't get overlooked that much, but understanding that it may not even come up for several years down the road, right? And you can't always protect against everything, and you have to balance that versus the business side of it, which is a seller really going to agree to a 7-year liability on an infringement? They might tell you to pound sand, right, type thing, but these are definitely things to think about and try to make sure that you're not caught off guard. If you buy something, next thing you know, you get a slap with a lawsuit, and then now you're in an infringement litigation, which are not cheap at all and can take a while to unravel and get through and stuff like that. So trying to do when I look at what is our job as attorneys and what do we do for our clients, at the end of the day, it's hopefully providing them a higher level of protection, a higher level of avoiding a liability than they would if they didn't use us, right? And so that's what we try to focus on. Obviously, you can overkill that because you got to balance that with getting deals done, and the only way to be 100% protected is just don't do any deals, right? So that's not the right answer. So it's finding that right balance between protection versus limiting liability. So I think we're a little bit over our 30 minutes, but that's basically kind of a good snapshot of kind of hopefully a good intro for investors and IP and what to kind of look for. Does anybody have any questions that they want to shoot out, or if there's not too many people jumping and talking, I don't mind if you want to open up the mutes too, if you want to unmute them or two. Okay. I guess you can unmute if you want to, if anyone wants to jump in and ask something if they don't want to type it. I have Vanessa, good question. So Vanessa in the chat posted, how do we think NFTs will affect the copyright world? We were talking about this the other day. I don't know that there's a great answer yet to that. And for those that don't know what NFTs are, I may butcher the explanation of it, but basically the idea is that the best way I can explain it is you have a Picasso who makes a painting and it's an original, right? It's a one of a kind. Well, if you go to sell that, especially over the years, right? How do you know it's that Picasso's an original? How do you know it's not a fake? How do you know it's not a replica? So on and so forth, right? So we have all of these, art experts that do some sort of, chemical analysis and look and verification and blah, blah, blah. And they've come up with something that's probably less than perfect, but tries to identify whether it's an original or a fake. So NFTs are now a digital original work of art, basically. So they create kind of a token of originality for, maybe it's a clip of a video, maybe it's a song, maybe it's a digital work of art, things like that. And then it creates this verification process where you can prove that it's an original. And so these things are starting to gain some value. So I think there's one, like the NBA's jumped into this a lot too. So they sell an original video of LeBron James dunking on someone. And so that becomes the original clip, and it gets this NFT, this token associated with it, so on and so forth. How does it affect the copyright world? I mean, I guess in some ways if you own the NFT, the question will be is, do you then own, does the copyright go with it, right? So that would be the first question. So are you now the official copyright holder of that? And if you are, then, if you see those being replicated out there, in theory, you'd be able to go after them for copyright infringement if you filed for a copyright registration. But I think it's very early on to be able to know exactly how that's going to work. But in some ways, it should make it a little bit easier, in the sense of if you have the NFT for that work of art, in theory, you should be able to prove that you're the copyright owner much easier, and then be able to go and enforce that if it's infringed upon. But yeah, I think there's just a lot of unknowns about how that's going to come into play. It's still certainly super early in the NFT world to kind of probably make much prediction. That it's all a guess, I think, at this point. But it'll be interesting to watch and to see, as you guys probably are aware, and maybe everyone's painfully aware, the law is typically lags behind the technology and all of these types of things, right? The law is still trying to figure out how to deal with cryptocurrency, let alone NFTs, right? So, it'll probably be a while before we get some sort of movement or clarity from a legal perspective on how these are going to intertwine. So, but thank you for that. Excellent. So we did a little quick drawing. Max E, you are the winner of the Amazon gift card. So thank you very much for attending. If anyone has any more questions, please let me know. Otherwise, you should have my email. You can reach out to us. Really appreciate your time, and hope you guys have a great rest of your day.